While they take that sidebar, let's bring in our guest who is standing by this hour to discuss. National Trial Attorney Michael Jaafar is with us. Michael, we've got a first responder on the stand. They're going to be talking about perhaps the reaction from Christine Ricci, but we know there's this issue where she said, my husband just simply collapsed, and it's not until they started taking off his clothes that they realized, wow, he's actually been stabbed. How do you resolve that if you're the defense?
You have no choice but to say that she was in shock, right? When the defense takes a case, they're going to have to tell a story. We know kind of what the story is going to be. They alluded to it in their opening statements, right? That the victim was troubled as well as their client, and that the victim was a bizarre person, acted erratically, and their client was basically the victim. She was the person who was just responding to stuff, and she was in shock, and she had just murdered the father of her children while her daughter was home, and so she was just in a state of shock. That's really the only way to do it, right? Because you're not going to be able to throw out the evidence of this first responder, right? She's testifying to what she saw at the scene. Yeah, I was there, and nobody was trying to do first, responders or mouth to mouth or chest compressions. Even though on the 911 call we heard them tell the daughter, do chest compressions, do this, do that. So we know that they were telling her to do the family to do that. They were talking to the daughter on the 911 call, and the mom was there in earshot, but nobody was doing anything to help this guy. I think it's compelling evidence against the defendant, so the defense is going to have to contend with it, and the only way to contend with it is she was in shock. This is what happened. That's it. There's no other way to sanitize it for the defense.
Yeah, that may be what we see when the defense starts.
Well, this case is in its early stages, and we're still hearing from first responders. All right, so they're going to take their mid-morning break over there, but this is a good time to discuss all of this because that's key testimony. This is key testimony, but in which way do you interpret that testimony?
It's an observation of Christine Ricci right there when it happened, and the life-saving measures is the part that keeps coming up. She wasn't doing that when these first officers
But she was also
on the scene.
in shock, according to the defense attorneys. Let's ask National Trial Attorney Michael Jaafar, which way did the ball get moved with this testimony?
I love this for the defense. That defense attorney did a fantastic job, right? When you go to law school, they tell you, hey, lawyers never ask a question that they don't know the answer to. It seems kind of silly, right? And then you find out in law school, oh, they're talking about in a trial context, right? You only ask questions you know the answers to. And the way you know the answers to is you've looked at all the underlying evidence. This defense attorney has studied the record. He has studied the witnesses and the observations that happened at the scene of the crime. And he knew exactly what he was coming into. When she was on direct examination, the prosecutor tried to paint a picture where, and it worked until the defense attorney came up. She tried to paint a picture where she stabbed him. She was doing nothing. She was not doing any type of CPR. She didn't care, and she didn't even tell them about the stab wound. They were going down a wild goose chase thinking he had choked or had a heart attack, when in fact she knew all along that she had stabbed him. And so the defense attorney came up there and he just dismantled all of it. I think he did a fantastic job. He brought it home, especially with his recross examination. He made the jury. He brought them back to what he wanted them to believe, which is, look, she was hysterical, she was in shock, but she still told them what happened. And by the way, she gave them enough space to work, which we all know that when you're not professionally trained, a jury is going to believe that a defendant, that a person at the scene of a crime is not going to get up in the face of the first responder and tell them, do this and do that, right? So for him to put it in the jury's mind that, hey, I told you this all along, I think he brought it home. He did a really fantastic job. I think this went in the favor of the defense.
The Commonwealth has another witness on the stand that we're going to take you to after this quick break.
You know what? This allows us time to bring in National Trial Attorney Michael Jaafar, who's watching along with you at home. He's on cross right there. It's so critical whether this jury believes that he was shot from the front or the back, because obviously she claims that he was charging towards her. So what was your takeaways from this?
That defense attorney really wants the testimony that he knows that this lead investigator is going to give him, and this has already been discussed and ruled on by this judge in a pretrial hearing, and we already know that there's a lot of tension between this judge and this defense attorney that started before the trial began. At the end of the day, the defense so far is putting on a good case. I think that the prosecutor and her line of questioning questioning when she was cross-examining Ashley Benenfield last week was terrible, was awful for the prosecution, great for the defense. But this is a little bit clumsy. I know what this defense attorney is trying to do. He's doing his job. Sometimes as a defense attorney, you don't really want the jury to hear the answer. You want them to hear the question, right? And so she's not even letting him ask the question. Think about it. Why won't she let him ask the question and then object? Some of the questions she just objected before he said, do you believe, and then she just objected. Why? Because she knows, like any trial attorney knows, once the jury hears the question, they cannot unhear it, right? And then even if they don't hear the answer, they've heard the question. And so it's poisoned their mind, and that's what you want. You want this jury to go back, because you know that these cases are Rorschach tests for juries. They're a Rorschach test, right? This case is a direct line from the case just before the Marsha Thompson case, both of them in Florida, both of them involved the same defense. This defendant actually is only charged with murder 2. Thompson was charged with murder 1. And in that case, we know that she shot her husband 9 times while he was sitting down, laying down, right? And she was a trained police officer, custom patrol officer, and she was wearing a vest when she did it, and she got acquitted. This defendant is the opposite. She has much better facts, and her defense attorney, you could tell he really wants this jury to hear that she shot him while he was charging at her, right? And he knows that he's dealing with a client that might not be as sympathetic as prior client. There's just some vibe you get. So this is clumsy. I'm really interested to see how they emerge from this sidebar, because, hey, the defense brought the lead investigator on. It's always very, very risky when you bring on the lead investigator in your defense case. So I'm really curious to see how they come out of this sidebar.
Oh yeah, I want to see how they end their defense case. They only have a few more witnesses, and then they are going to rest their case. Michael Jaafar, thanks so much for all of your analysis this hour. We have gotten to a lot already today in both